Greetings, everyone. Thank you for joining us for today's webinar, our year-end compliance update. My name is Destiny Esper, and I am the Content and Media Manager here at AccuSource. I will be today's moderator. Today's presentation will last approximately 45 to 50 minutes with a Q&A session to follow at the end. Please submit any questions you have via the chat function of the GoToWebinar software. We will answer as many questions as we have time for live. However, if time does not permit, we will answer questions on an individual basis post-webinar. A copy of this presentation will be available within 48 hours. If you would like a copy of the recorded presentation, please contact us at marketing@AccuSource-online.com, and we will be happy to provide that to you. As we get started, I'd like to introduce you to today's presenter and AccuSource's Vice President of Compliance and Regulatory Affairs, Beth Axelrod. Beth is a 20-year veteran in the field of regulatory compliance with over 15 years of compliance experience in the employment screening and human resource services industry at some of the country's largest consumer reporting agencies. She provides subject matter expertise and support to current and prospective clients as well as staff members. Beth's knowledge and experience in the compliance field with expertise in information technology, consumer reporting, privacy legislation and advocacy, employment law, and hiring practices has aided employers and workplaces throughout the country and ensured safe workplaces while ensuring legally compliant employment practices. Now, without further ado, I would like to pass it along to Beth Axelrod. Beth?
Good morning, everybody. Today we'll be covering quite a bit of material, so I will be moving relatively fast to get through all the slides. We will have time after for questions and answers, and I'll be happy to follow up with any questions that I'm not able to address during this hour session. Today we'll be covering year in 2017. It's been a very busy year in the employment and background screening arena. Today we'll be covering several of the significant developments that occurred in the past year, as well as to what to expect for the coming year. The 2017 year in review will include EEOC's three-pronged test, fair chance legislation, otherwise known as ban the box, salary history bans, an update on Spokio versus Robbins, and recreational marijuana use laws. I will then be discussing what to anticipate in the regulatory environment for 2018 and conclude with some best practice recommendations. Before we move on, I do need to point out that the content provided in this presentation is for informational purposes only. It should not be construed as legal advice or serve as specific guidance. AccuSource strongly encourages current and prospective clients to seek the advice of qualified counsel, preferably specializing in employment law prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. For our discussion today, I do want to indicate that the scope of this presentation will not be inclusive of certain exemptions that may exist for certain employers. Many employers are prohibited by law from employing ex-offenders in varying circumstances. California and other state laws all recognize that various regulated industries have other rules that may override some of what is being discussed today. It's important to consider whether any of these exclusions apply to your business. Additionally, federal law governs access to and the use of credit reports. California and other jurisdictions may restrict the use of credit reports in certain instances. The discussion on records today is only with regard to criminal records. Now to the heart of the presentation. In order to better understand the legal environment today with regard to employment background screening, it helps to understand some of the history behind recent developments if you're not already aware. One such important item to know is what is referred to as the EEOC three-pronged test. On April 25, 2012, the U.S. Equal Employment Opportunity Commission, otherwise known as the EEOC, which is the agency that enforces federal laws prohibiting employment discrimination, voted 4-11 to update the enforcement guidance on consideration of arrest and conviction records in employment decisions under Title VII of the Civil Rights Act of 1964. This act prohibits employment discrimination based on race, color, religion, sex, national origin, and other factors. The EEOC enforcement guidance was developed to help eliminate unlawful discrimination in employment screening, hiring, and retention. The 2012 guidance does not prohibit employers from using criminal records, but rather outlines best practices that the EEOC advises employers to follow, including a recommendation that employers, among other things, do the following. Remove from employment applications the question that asks job applicants to self-disclose their criminal record, not make an employment decision based solely on the fact of an arrest record, and conduct an individualized assessment before rejecting an applicant or terminating an employee because of a conviction. This was a result of what the EEOC has referred to and what is now commonly used in similar state legislation as disparate impact. Disparate impact occurs when policies, practices, rules, or other systems that appear to be neutral result in a disproportionate impact on a protected group. For example, testing all applicants and using results from that test that will unintentionally eliminate certain minority applicants disproportionately would be considered disparate impact. The 2012 guidance is not a rule or a regulation and therefore does not have the force or effect of law, but it is the EEOC's position on enforcement of Title VII regarding criminal records, and therefore it is an important document for employers to be aware of. Employers that don't follow the EEOC guidelines can be subject to an investigation and litigation by the EEOC, as well as private lawsuits by individuals that may allege a failure to hire based upon discriminatory criteria. Although courts are not required to accept the EEOC position, courts will generally consider the guidance in any litigation. If a discrimination complaint is lodged, an EEOC investigator may look to see if there's a pattern or practice of discrimination, and the guidance can become an important consideration in those situations. In order to help facilitate employment of ex-offenders and help avoid disparate impact, a number of cities, states, and counties across the U.S. have joined what is referred to as the Ban the Box movement, which we'll be discussing a little further in this presentation. The goal is to remove the box on job applications where applicants are asked to check whether they have a criminal record next to the question about past criminal arrests and convictions. By removing this question, supporters suggest that job applicants will not be automatically excluded for consideration for a job because of their past mistakes, and those applicants with criminal past are given a fair shot in the process. The concern is that by asking about a criminal record early in the process, job applicants essentially face a lifetime ban on employment for many jobs. The ideal is that an appropriate background check can still be conducted before the job is finalized. But ex-offenders should be afforded the opportunity to at least compete for a position in the first place before criminal record results in being disqualified. While measures designed to promote public safety and a safe workplace with honest and qualified employees is very critical and helps prevent against negligent hire claims, blanket policies related to past crimes can create a barrier for ex-offenders to get a job. Without a job, they are more likely to go on to commit more crimes. The issue is how to strike a good balance and draw lines that both protect innocent people and at the same time doesn't eliminate ex-offenders from the job market. According to the EEOC, an employer's use of an individual's criminal history in making employment decisions may, in some instances, violate the prohibition against employment discrimination under Title VII. An employer's reliance on a criminal record to deny employment may violate Title VII if it can be determined that either disparate treatment or disparate impact occurred. While with disparate treatment, a violation may occur when an employer treats criminal history information differently for different applicants or employees based on their race or national origin, disparate impact liability can occur even if an employer's neutral policy may disproportionately impact some individuals protected under Title VII and may violate the law if not job-related and consistent with business necessity. Under a disparate impact approach, an employer can be liable even if they did not subjectively intend for any discrimination to occur. It is not an issue of what the employer intended, but rather what actually resulted from the employer's policies and procedures. The EEOC has long taken the position that an employer should not automatically reject an applicant with a criminal record, without taking into consideration whether the matter is related to the job so that there is a business necessity to deny employment. The EEOC recommended in 1987 that employers first analyze 3 factors: the nature of the crime, the time elapsed, and the nature of the job. This 3-part test is known as the Green Test, based upon Green versus Missouri Pacific Railroad. The new EEOC guidance enhances the 3-part test with more detailed definition. The nature and gravity of the offense now includes harm caused, elements of crime, and classification of the offense, such as whether it's a misdemeanor versus a felony. Time elapsed now includes evaluation of the tendency to recommit offenses. And the nature of the job now includes to look at more than just job title, but also evaluation of specific duties, essential functions, and circumstances such as whether the position is supervised or not, and the environment such as if it's in a home or factory, for example. In addition to federal EEOC laws, U.S. cities, counties, and states have adopted new fair hiring policies. Nationwide, there are currently over 150 cities, municipalities, and counties that now have what I refer to as ban the box law that can apply to public, private, or both types of employees. The most recent being Spokane, where on November 27th of this year, the Spokane City Council approved a ban the box ordinance. The mayor has until December 14th, 2017 to veto or sign the ordinance, so this is something that you probably want to put on your radar in the coming months. And the box laws, also called fair chance or fair opportunity laws, prohibit employers from inquiring about prior criminal convictions until a later point in the hiring process. The laws make it illegal to include a checkbox on a job application that asks about criminal history, and in some cases during an interview, until later in the hiring process, such as after an offer is made and can be investigated upon consent of the applicant. Ban the box laws are designed to provide applicants a fair chance by removing the conviction history question on the job application and delaying the background check inquiry until later in the hiring process. California recently became the largest jurisdiction to pass a ban the box law. Current California law already prohibits the consideration of certain criminal records in a hiring decision. Under current California Labor Code, employers are prohibited from considering or seeking information about certain types of criminal records, including an arrest or a detention that did not result in a conviction, certain marijuana infractions and misdemeanor convictions that are older than 2 years, referral to or participation in any pre-trial or post-trial diversion program, an arrest, detention, processing, diversion, supervision, adjudication, or court disposition that occurred while a person was subject to the process and jurisdiction of a juvenile court, convictions that have been sealed, judicially dismissed, expunged, or statutorily eradicated by law, and to any non-felony conviction for possession of marijuana that is older than 2 years. On October 14, 2017, Governor Jerry Brown signed Assembly Bill 1008, which will add a section to the California Fair Employment and Housing Act, otherwise known as FEHA, containing new statewide restrictions on an employer's ability to make pre-hire and personal decisions based on an individual's criminal history, including a significant and far-reaching ban-the-box component. This new law goes into effect on January 1st, 2018. Existing law currently already prohibits state and local government agencies from asking an applicant to disclose conviction information until the applicant is determined qualified for the position. AB 1008 extends this prohibition to all employers in California with 5 or more employees. The bill will make it unlawful for California employers with at least 5 employees to include on any application for employment any question that seeks the disclosure of an applicant's conviction history, inquire into or consider the conviction history of an applicant before the applicant receives a conditional offer of employment, and consider, distribute, or disseminate information about any of the following while conducting a criminal history background check in connection with any application for employment: an arrest that did not result in a conviction subject to the exception in Labor Code 432.7, referral to or participation in a pretrial or post-trial diversion program, and convictions that have been sealed, dismissed, expunged, or statutorily eradicated pursuant to law. Under AB 1008, consideration of an applicant's criminal history will be permissible only after the employer has made a conditional offer of employment. Once that offer has been made and the criminal history obtained, AB 1008 further provides that the employer cannot deny an applicant a position solely or in part because of a conviction history until the employer performs an individualized assessment. This assessment must justify denying the applicant the position by linking relevant conviction history with specific job duties of the position sought. In particular, the assessment would have to consider those aspects previously discussed in the EEOC Green Test, which are the nature and gravity of the offense and conduct, the time that has passed since offense or conduct and completion of the sentence, and the nature of the job held or sought. AB 1008 does, however, provide that employers may, but is not required to commit the results of this individualized assessment in writing. Once the employer makes a preliminary decision that the applicant's conviction history is disqualifying, the employer must notify the applicant of this preliminary decision in writing. However, the employer is not required to justify or explain to the applicant its reasoning for making the preliminary decision. This is a service that AccuSource provides as part of its pre-adverse adverse action process. Whether performed by the employer or by the background screening service provider, the following actions must be taken. The candidate must be provided with a written notice of the disqualifying conviction or convictions that are the basis for the preliminary decision to rescind the offer. A copy of the conviction history report, if any, must be included, and an explanation must be provided that the applicant has a right to respond to the notice within at least 5 business days. The employer cannot make any final determination based on the conviction history during these 5 business day business day period. If the applicant timely notifies the employer in writing that he or she is disputing the conviction history and is taking steps to obtain evidence to support this, the employer must provide 5 additional business days to respond to the notice. The employer must also consider any additional evidence or documents that the applicant provides in response to the notice before making a final decision. If the employer ultimately decides to deny an applicant based on the conviction history, the employer must notify the applicant of this in writing and include notification of any existing procedure that the employer has to challenge the decision, as well as notification of the applicant's right to file a complaint with the Department of Fair Employment and Housing. In light of AB 1008 and similar ban-the-box laws, California employers as well as other employers located in a similar ban-the-box jurisdiction that use criminal records to screen applicants or employees should consider a privileged review of all the various policies, procedures, and other documents related to the screening process, such as job applications, offer letters, guidelines for recruiters, etc. Relatedly, if not done already, employers should consider updating all documents related to federal and potentially California Fair Credit Reporting Act compliance, including background check authorization and disclosure forms and adverse action notifications. This is also something that AccuSource is currently reviewing to ensure its documents are all compliant with the new California ban-the-box requirements where applicable, given that there are new details involved in the notices with this new law. While it is always recommended to discuss with your legal counsel, it may be best and is recommended to remove the conviction question from all applications being used, regardless of where the business is located or where the applicant resides, to avoid any confusion and potential non-compliance. Another area that seems to be picking up momentum around the country is in regard to questions around previous salary. Multiple cities and states have passed laws recently banning employers from asking a job candidate for their salary history during the employment screening and interviewing process. Advocates of these new laws say it's to redress the persistent gender pay gap in America. It's estimated that women still earn on average about 80 cents to a man's dollar nationwide, according to the National Women's Law Center. On October 12, 2017, Governor Jerry Brown of California signed into law AB 168, which applies a statewide ban on employer inquiries into an individual's salary history. California is now the largest state so far to enact a salary history ban. The new law will apply to all employers regardless of size and industry, including state and local governments, and will take effect also on January 1, 2018. With AB 168, California joins the growing list of jurisdictions across the country that now prohibit salary history inquiries. A similar but perhaps more comprehensive ordinance was passed in San Francisco and will become operative on July 1, 2018. New York City's salary history ban took effect on October 31, 2017, and imposes severe penalties for violations. Other states that have recently passed salary history prohibitions are Delaware, Oregon, Puerto Rico, Pittsburgh, and New Orleans. Philadelphia's ban the box has been put on hold pending a legal challenge, but something to still be aware of. And legislatures in New Jersey and Illinois have also passed similar laws which were vetoed by their governors, not to say that these won't be reissued with different language. The rationale underlying these laws is that pay inequities are perpetuated when current pay is based on past employer decisions that could have been discriminatory. To combat this problem, these measures seek to narrow the pay gap between men and women by emphasizing the value of a particular position rather than the value of an individual as based on his or her prior earnings. The new California law continues the expansion of equal pay protection in California. California's equal pay law has been on the books since 1949, requiring equal pay regardless of gender for equal work. It remained largely unchallenged until more recently in 2016, when it was amended to require equal pay for substantially similar work. In addition, the 2016 revision prohibited employers from using prior salary to justify a current disparity in compensation. AB 168 imposes further restrictions and requirements regarding the salary history information of a job applicant. Under AB 168, an employer cannot rely on an applicant's prior salary history as a factor in determining whether to offer employment or what salary to offer an applicant. Salary history information includes both an individual's rate of compensation as well as other benefits like bonuses. Moreover, an employer is prohibited from seeking this type of information about an applicant either orally or in writing, either directly or indirectly. Accordingly, employers and their agents can no longer ask candidates or their current or former employers what candidates have earned in the past. An employer must, upon reasonable request, provide an applicant with a pay scale assigned to the position sought. There are certain exceptions to the salary history restriction. First, employers may review and consider salary history information that is publicly available pursuant to federal or state law. And second, salary history may be discussed if an applicant voluntarily and without prompting discloses his or her history to a potential employer. In that event, the employer may consider and rely on that history in setting that applicant's salary. Please bear in mind that there are certain exceptions. Employers may review and consider salary history information that is publicly available pursuant to federal or state law, and salary history may be discussed if an applicant voluntarily and without prompting discloses his or her history to a potential employer. In that event, the employer must consider and rely on that history in setting that applicant's, may consider, not must, on relying on that history in setting that applicant's salary. In light of this new law, employers with operations in California should revisit their current recruitment processes, including applications and train hiring personnel, to prepare for compliance with these new requirements. Employers should also bear in mind that even where consideration of salary history is permissible, prior salary cannot by itself justify disparity in compensation between workers of the opposite sex who are performing substantially similar work. Please also keep in mind that if you're a company based in a city or state that currently does not have a salary history ban, you may be dealing with job candidates who are. many legal experts seem to agree that it is probably safest to just take the salary question off for everyone. It is expected that other states will soon be joining along, so it might be best to get ahead of it. There's been a lot of discussion around the ongoing case of Spokio versus Robbins. At issue in this case is whether a person may invoke the jurisdiction of federal courts under Article 3 who suffer no concrete harm and who therefore could not otherwise invoke jurisdiction of a federal court by authorizing a private right of action based on a bare violation of a federal statute. More clearly stated is that this case brought into question whether a person can bring a lawsuit when a company violates a federal privacy law without actual harm being demonstrated. By way of background, Spokio operates a people search website that instantaneously pulls together information from publicly available sources, including contact data, marital status, age, and occupation, among other things. Some of this information is subject to protection under federal privacy laws. In 2011, a Virginia resident named Thomas Robbins filed a putative class action lawsuit against Spokio for willful violations of the Fair Credit Reporting Act, alleging that the information about him on the site was largely erroneous and harmed his employment prospects. The district court dismissed the case, finding that where no injury in fact is properly pled, a plaintiff does not have standing to sue. In February 2014, the U.S. Court of Appeals for the Ninth Circuit reversed this decision, holding that the violation of a statutory right is usually a sufficient injury in fact to confer standing, and that a plaintiff can suffer a violation of the statutory right without suffering actual damages. Spokio asked the U.S. Supreme Court, Spokio asked the U.S. Supreme Court to consider the ruling. In its petition, Spokio posed the question whether Congress may confer Article 3 standing upon a plaintiff who suffers no concrete harm and who therefore could not otherwise invoke the jurisdiction of a federal court by authorizing a private right of action based on a bare violation of a federal statute. Spokio argued that Robbins' bare allegations of FCRA violations without any accompanying concrete or particularized harm were insufficient to establish an injury in fact, and thus failed to establish Article 3 standing. The U.S. Supreme Court remanded the case for the Ninth Circuit to determine whether the plaintiff had alleged a concrete injury. On remand, the Ninth Circuit concluded that the plaintiff had sufficiently pled a concrete injury in fact, and thus had standing to proceed with his FCR claims. The court stated that although a plaintiff may not show an injury in fact merely by pointing to a statutory violation, some statutory violations alone do establish concrete harm. The court concluded that this position protects consumers' concrete interests in an accurate reporting and consumer privacy, and that these interests are real rather than purely legal creations. Upon examination of the nature of the specific alleged reporting inaccuracies, in order to ensure that they raise a real risk of harm to the concrete interests that the FCRA protects, the court concluded that while a benign inaccuracy may not be harmful, the plaintiff had raised a real risk of harm by alleging that the defendant had inaccurately reported information that may be important to employers or others making use of a consumer report. Thus, a materially inaccurate report is itself a concrete injury. So what does this all mean in practical application? In Spokio, the U.S. Supreme Court held that to be sufficient, an injury must actually exist, and clarified that not all inaccuracies cause harm or present any material risk of harm to a plaintiff. The Ninth Circuit held that an inaccurate report is itself a concrete injury, even if the only people who received the report were the plaintiff and his lawyer. The threat to a consumer's livelihood is caused by the very existence of inaccurate information in his credit report and the likelihood that such information will be important to one of the many entities who make use of such reports. Thus, a materially inaccurate report is itself a concrete injury. The Ninth Circuit's opinion is difficult to reconcile as it also seems to conflict with another decision of the Fourth Circuit with the ruling in Dreher versus Experian Information Solutions. In that case, the plaintiff sued a consumer reporting agency for inaccurately identifying the source of credit information in his report. The Fourth Circuit rejected the plaintiff's argument that the inaccuracy itself was an injury. Instead, the court held that a plaintiff must show that he was adversely affected by the alleged error on his report. The court reasoned that an inaccuracy works no real harm unless it has a negative impact on the consumer. If the divide on Spokio's application deepens among the federal courts of appeal, the U.S. Supreme Court may revisit the standing issue to provide more clarity. Why does this all matter to employers? It matters because class action lawsuits have been brought against employers in regard to their background screening practices, and many of these class actions are based on the employer screening program allegedly not meeting the requirements of federal law, even though no actual damages are claimed. If the Supreme Court rules actual damages are necessary, cases like these against employers would likely become much less frequent because proving actual harm would be difficult and time-consuming. Employers would be less likely to be sued in a class action over their background screening practices, thereby reducing legal costs, settlements, business disruption, and brand damage. For now, however, consumers may be able to bring FCR claims in federal court whenever the reports contain inaccurate information, unless that information is truly benign. For this reason, employers obtaining background checks should be careful to comply with each of the FCRA's highly technical requirements. Failing to comply with a requirement could expose a company to class action liability, even if the violation did not impact hiring. Employers should consider conducting a privileged compliance review of their background screening process, including the notices used and the procedures followed for obtaining and using background reports. Employers should also review their policies regarding requesting and using salary history and criminal history in light of the increasing number of jurisdictions that restrict use of such information, and the Equal Employment Opportunity Commission's continued interest in background screening policies that may have a disparate impact on minorities. For now, however, consumers may be able to bring FCR claims in federal court whenever their reports contain inaccurate information, unless that information is truly benign. For this reason, employers obtaining background checks should be careful to comply with each of the FCR. Oh, I'm very sorry, we have a duplication here in notes. Okay. So we've finished with our recommendations in regard to Spokio versus Robbins. Moving on to the next topic, I apologize for that. Recreational marijuana use laws. Another issue currently being faced by many employers is what to do with regard to drug testing in light of recent marijuana use laws. As marijuana legalization for recreational purposes has been passed by several states, employers are conflicted about their policies of drug testing. The question that arises is whether employers can still drug test where marijuana is now legal. The quick answer is that in many states where marijuana has become more accessible and legal, employers can still drug test for marijuana. It would be great if the rules were clear from state to state and across the country, but the reality is you're facing a mixed bag of guidelines over the next couple of years. Further complicating things is that even when an employer is allowed to drug test, these tests don't show whether someone is cannabis intoxicated at the time of the test. Similar to a blood alcohol test, they only show whether there's THC in the bloodstream, and this can be fresh THC or residual from several days earlier. So theoretically, the employee who acquires and smokes marijuana legally on the first day of a 2-week vacation and then is drug tested upon returning to work, which should only happen, by the way, if the employer for some reason suspects that the employee had a drug problem, can very possibly test positive and lose his or her job. Marijuana is now legal for recreational use in Washington, Colorado, Oregon, and Alaska, joined by California, Massachusetts, Maine, and Nevada. For the most part, states' marijuana legalization laws do still support employers testing for marijuana use and firing people for it. Here's a quick rundown of what some of the new marijuana laws say with regard to drug testing. In Massachusetts, the law maintains the authority of employers to enact and enforce workplace policies restricting the consumption of marijuana by employees. In Alaska, companies that had drug testing policies in place were allowed to keep using them. Those who had none could not immediately start testing until they carefully followed a series of protocols to ensure employees are being treated fairly. Otherwise, employers would not be immune to legal consequences. Steps include creating clearly defined rules, such as which employees the policy applies to, and identifying the consequences of testing positive or refusing to be tested. Companies also have to provide written copies of the policy and do so at least 30 days before it takes effect. In Nevada, when voters approved the rules for drug testing, when they approved the rules for drug testing employees, the rules were unchanged. According to the rules, public and private employers are not prohibited from maintaining, enacting, or enforcing a workplace policy prohibiting or restricting actions or conduct otherwise permitted under the Act. In Washington, like Alaska, employers are still allowed to conduct drug testing according to their written policies. And in California, it's pretty straightforward. California's Proposition 64's ballot summary says, the proposition will not amend, repeal, affect, restrict, or preempt the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace, or require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace, or affect the ability of employers to have policies prohibiting the use of marijuana by employees and prospective employees, or prevent employers from complying with state or federal law. So they've made that pretty clear. To sum it all up, the good news for employers is that they can still maintain the drug-free policies they've had in place for years. Employees, however, are likely to be more confused than ever. Employers are well advised to explain to their employees that even if recreational marijuana is legal, if they use marijuana, they can still lose their job if they test positive for it. Same goes for job applicants. If the applicant passes a contingent offer drug test and is hired, but later on the employer has a reasonable suspicion that the worker is impaired because of marijuana use, the employer can require the worker to take a drug test and fire the worker if they test positive. Further complicating matters for workers is that all of this will unfold under a much bigger cloud of uncertainty with the new administration at the federal level and how much the U.S. Drug Enforcement Agency chooses to enforce relevant sections of the Controlled Substances Act. The best news for employers out of this is that they can continue to enforce workplace policies on drug or alcohol impaired workers. For employees, however, marijuana use will continue to be a complicated and somewhat risky issue. So, as the new year is fast approaching, what can we expect in the year to come in 2018? In a nutshell, we can probably expect more of the same. Human resource professionals conducting pre-employment background checks in 2018 will have to adapt to the growth of the Ban the Box movement and other restrictions placed on what you can and can't ask with a pre-offer candidate. Civil rights groups and others view Ban the Box initiatives as important towards re-entry efforts by ex-offenders. The argument being that these measures reduce unfair barriers to employment for those with criminal records. The concern is that their employment application will be automatically rejected just based upon their status as ex-offenders, as opposed to what they can offer an employer. That, however, does not mean that a background check will not be conducted or that an employer cannot exercise appropriate due diligence, but just that it is delayed until later in the process. The EEOC supports this approach for all private sector employers, although not yet a national mandate. Many employers have adjusted their practices to accommodate these laws by removing the criminal history question from all job applications. However, bear in mind that the laws have increased in complexity, so it's important to become familiar with the various requirements and not just feel you're safe if you just remove the question from your applications. We will also probably see more salary question bans coming down the pipe, with fair pay laws coming to the forefront. The EEOC is actively looking into employers' pay practices as it relates to gender disparities. 9 jurisdictions have now adopted salary question bans that apply to private employers. These are Philadelphia, California, as previously discussed, New York City, Delaware, Massachusetts, San Francisco, Oregon, Puerto Rico, and Albany County, New York. New York and New Orleans and Pittsburgh currently have restrictions that apply only to public sector employers. The upside to the legislation is fairness for candidates, focus more on the value of the work itself, employees' past experience and performance, as well as market factors. The downside is that the brunt of the compliance challenges fall on employers because they have to set those salaries and change the way they negotiate salary. In addition, complicated situations may arise if the candidate volunteers information or when a very good candidate doesn't accept the pay range. These new laws also come along with new challenges that employers and background screeners may face with regard to background procedures and report accuracy in light of the recent Ninth Circuit Spokio decision. Employers and background screeners can potentially face federal court claims and class action lawsuits should procedural noncompliance or report inaccuracy be demonstrated without having to show damages were actually incurred. Lastly, as far as marijuana legalization, whether more states follow suit is hard to say given the current administration, but whatever develops next in policy is likely to be shaped by data from the earlier legalizers and whether the federal government decides to step in. It's really too early to draw any conclusions about the potential effects of marijuana legalization or commercialization on public safety and the workplace. For the present, however, employers are still afforded the ability to craft a drug testing policy that meets their company's needs and comports with applicable laws. And employers may still require pre-employment drug tests and take illegal drug use into consideration in making employment decisions. This leads us to the next question. What is an employer to do with all of this? As mentioned earlier, it is recommended that employers perform a thorough review of its current screening and hiring practices and revise any employment policies and practices to comply with the new laws. With AB 168 going into effect on January 1st, employers would be well advised to revise their application forms if they haven't done so already, to delete questions asking for salary or wage history. Employers should also ensure all recruiters and hiring managers are trained to not ask such information in interviews. Instead, you may want to ask applicants for salary expectations and requirements. Lastly, with AB 1008 also going into effect come January 1st, employers may also want to revise their application forms to delete any questions about criminal history, arrests, and convictions. Conduct a review of current processes and revise any policies or practices that place a blanket exclusion on employees with criminal convictions. Furthermore, employers should ensure that they develop appropriate procedures for evaluating criminal history and for notifying applicants of disqualification and allowing them to respond in accordance with the new requirements. With increased enforcement efforts by the EEOC and FEHA and other federal and state regulatory agencies to ensure employers are complying with their requirements, employers need to arm themselves and ensure they're meeting their requirements by taking a close look at their current practices and those of its vendors and ensure proper training for all HR-related staff. This concludes our presentation and brings us to the question and answer time for our presentation. I'll be happy to answer any questions you may have.
Okay, thank you so much, Beth. That was a lot of really great information, and we really, really appreciate it. At this point, we'd like to delve into some of the questions we received for this webinar in our Q&A session. So I will turn it over to AccuSource's Vice President of Sales and Marketing, Cynthia Wood. Cynthia?
Yes, first question is, with regard to salary bands, what jurisdictions should apply?
So that's actually been a common question that I've come across because it kind of goes into that whole jurisdiction question that arises in a lot of these reporting, consumer reporting requirements. But basically, it's probably, you know, something you do want to talk with counsel on to make sure you're covering yourself. But the way that most of these are written does go with where the employer is doing business. However, as you post applications out, you know, on your website where you don't really know where the candidates may be coming from, there's also the argument that they're protected under their jurisdiction. You know, if they, let's say, reside in California and are applying to a employer that is not located in a ban-the-box jurisdiction, the best recommendation I would have is to cover all bases, and that's why things are leaning towards just removing it entirely from the applications as opposed to trying to administer jurisdiction by jurisdiction. Any other questions?
Yes. So when in the criminal record, when in the employment process should you ask the criminal record question?
Well, if they're the regs, you know, the state regs that have the fair chance laws coming into play, as well as the EOC, you know, they recommend it further along in the process. So that's kind of the whole gist of, you know, these various state laws that are appearing that kind of mirror what the EOC has said in its guidelines. Unless I would recommend, again, you know, discuss with your counsel, but at least later in the process where you're, you know, about to, or where you're conducting an actual interview, where you've, you know, have dialogue with a candidate, and unless, you know, be careful, however, because like California's, there's some state requirements that actually require that not to happen, not even a background screen until post-offer. So a post-offer, an offer contingent on completion of the background screen. That would probably be the most prudent if you're going to, you know, be safe and play conservative, is after conditional offer is made. Any more questions?
Yes. Is the salary ban in effect in Minnesota?
I believe it is. I think that the ones that have just, don't quote me, I'd have to actually look. I can follow up with that because I don't, unfortunately, at the top of my head, have when each one went into effect. However, I think for the most part, all that I mentioned are in effect, except, like I indicated, California comes into effect, which is, you know, the largest jurisdiction to enact such a requirement. It goes into effect at first of the year, and then Spokane we have till actually next week, I believe it is, if the mayor is going to veto it or not. But otherwise, the ones that were mentioned should be in effect, and I'll follow up to confirm that.
Okay, and can you screen out applicants with prior DUIs for positions with driving duties, or obtain a CDL as a major part of the employment process?
So I believe this is getting at like sort of a two-step process where an MVR is conducted and you move forward if the MVR meets, you know, the requirements, and then if it doesn't, then no further action is taken with regard to criminal records. This is something to be really careful of. I would recommend that where there is a, you know, as far as on the federal level with the EEOC, there's nothing that currently prohibits that. the EEOC speaks to the criminal records in their guidance in terms of having it be much later in the process, so it doesn't specifically touch upon non-criminal records. However, there's more jurisdictions with legislation on the books that kind of speak a little bit more to the background screening process, and it is something that we're going to have to keep a close eye on and see how the legislation develops. With California, for instance, usually what happens is, there's the black letter law of what you read, and you have all these questions, and it rolls out January 1st, and then they usually issue, hopefully before, but they'll issue a Q&A where some of these, more detailed questions come into play and hopefully are answered. So in the meantime, you may take some risk if you're kind of slicing up the background screening process for certain jurisdictions. Any other questions?
And then the next question would be, what type of information should be included in a drug abuse policy?
Well, that is kind of a loaded question. There's a lot of new information coming out around this arena, and for purposes of time, I apologize, but I wasn't able to touch upon that in this presentation. The DOT has recently issued some new guidance, or new requirements, I should say, in relation to some of the quote-unquote newer types of drug use that's a little more prevalent today that we see with prescription medication and so forth. So it's really that really is very, very dependent on a lot of factors. So there's not one clear answer I can give today, but I'm sure we'll be issuing out more information on this on our website. But basically, things to consider is obviously whether you're regulated or not answers the question in terms of what you're supposed to do. And then if you're not, it's a matter of a safe workplace. So, what kind of environment are you in terms of, are you, are the employees going to be around sensitive groups like children or elderly? Are they going to be going into homes, like, working on people's television connections, or are they kind of, are they working in a factory, like, in a motorized, putting car parts together where it's not as sensitive perhaps. So those are all kind of things you need to consider in developing both your just general background screening policy as well as your drug testing policy. It's not a one-size-fits-all by any means, so something you want to pay close attention to.
Okay, and the next question is it appropriate to inform staff that the use of weed is illegal, but being impaired at work due to any substance may legally lead to employment termination?
Yeah, I think if I understand the question correct, and Cynthia, correct me if I'm wrong, if it's not just my mention of if you notice someone is under the, maybe under the influence, let's say, if you can test for that, and it's not necessarily just testing for the marijuana use. Is that what the question is?
Beth, I'm not sure. I'm just
okay. Well,
the question verbatim.
Okay. Well, as I think I understand it, and again, we could follow up with anyone after the call with questions. But basically with that, it's important to just have a solid policy in place in terms of what your stance is. That's what's going to protect you. And then if you see that somebody, if there's suspicion that someone may be in violation of that policy while on the job, you should be well within your rights to potentially ask to have a test, random test done. However, please keep in mind for that you do want to notate in your policy and in your handbook and so forth that that is, your right to be able to do. Otherwise, you could face some legal challenges. Any other questions?
I believe that's it for the questions today.
Great.
Denise?
Thank you, Cynthia. So at this point, we just want to extend our sincerest thanks to everyone who participated and attended in today's webinar. Again, a copy of this presentation will be available within 48 hours. If you would like a copy of the recorded presentation, please contact us at marketing@AccuSource-online.com, and we will be happy to provide that to you. If you had any questions that we did not happen to get to out of time restrictions or time constraints during this presentation, we will be sure to follow up after this. And aside from that, thank you all. You can find more information about AccuSource as well as our resources on our website, www.AccuSource-online.com, at any time. And we appreciate you joining us today. Thank you, Beth, and thank you to everyone in attendance, and have a great rest of your day.